Good afternoon or good morning, depending upon where you are joining us from today. My name is Devin Barry. I'm a partner at the law firm of Thompson Hine and a member of our environmental practice group. My co-presenters today are Joel Eagle, sitting to my left, and Tanya Nesbitt, who is on the webinar as well. Both are partners within the environmental practice group at Thompson Hine as well. We'd like to welcome you to today's webinar. This is the fourth of a series examining what the shift of presidential power could mean for the country and your businesses. And today we'll be discussing the Trump administration's anticipated approach to environmental laws and regulations. We will examine expected changes in US EPA leadership and potential impacts that might have on regulatory actions, pending rules, legal challenges, and the agency's future priorities. And I apologize if I sound like a robot for the next part. This is just some housekeeping items that we need to cover. So I'll cover the rules and then we'll kick off on the interesting stuff. So today's program will be recorded and we'll send you a link within the next few days. The presentation is intended for general information of individuals and organizations on matters of current interest. The thoughts and opinions expressed today are those of the individual panel members only and do not necessarily reflect the opinions of the panel members' clients, employers, or affiliates, or Thompson Hine. The content should not be taken as advice, as the views are expressed here solely for informational purposes. If you have any questions during the webinar, feel free to use the question box located in the control panel on the right side of your screen, and we will answer those questions as we are able to by the end of the webinar. CLE credit for today's webinar is pending. Please be sure to complete the verification of attendance survey. The link to the survey is posted to the chat. We will also paste the link in the chat at the end of the program. I will announce the attendance tracking code at the end of the program as well. And in the handout panel, you can also download a copy of the PowerPoint presentation that we will be going through and the bios for myself, Joel, and Tanya. Again, thank you for your interest as we go into this presentation. All right, so now that we've got the procedural stuff out of the way, here's today's agenda on the environmental issues that we're seeing with the Trump administration. We're going to walk through at a high level some of the changes that have been occurring with US EPA and US DOJ. We're going to walk through some of the executive orders. Certainly there's not enough time to go through all of them, and attempt to provide some practical pointers on how to deal with some of the uncertainty that is starting to arise out of the executive orders. So this slide is going to be a very brief summary of the massive amount of changes that occurred over the past month and a half. And Joel and Tanya are going to go more into the staffing issues and the implications. So I'm going to run through this fairly quickly. In January of 2025, one of the most significant things that occurred was that a memo essentially went out. I'm sure many of you perhaps had to deal with this as well. A memo went out to US EPA and DOJ, essentially putting in place a gag order, telling the agency that they were not allowed to interact with the regulated community. And this wasn't just relating to litigation or to enforcement matters. It related to remedial projects, compliance issues, permitting, everything. A pretty unprecedented approach. It lasted 2 to 3 weeks. It's now been lifted, but it also seemed to be somewhat unofficial. So there certainly are still restrictions in place, but certainly an unprecedented situation. There was a reassignment of several key section chiefs for the Department of Justice in the ENRD section, specifically for environmental claims. Tanya is going to go into that a little bit more, given her background with the DOJ. There was a halt in January as well of all pending litigation. To some extent, that's natural when a new administration comes in, but the extent of those requests for abayances of active litigation or restrictions on litigation moving forward, certainly something that's not typical with a change of administration, at least at the level that we've seen. Of course, you've probably seen the news, staffing changes. There's a requirement for all of EPA staff to come work back in the office 7 days a week. And lastly, last week, there was a pretty significant layoff where 171 employees that were dedicated to D&I or environmental justice were laid off by the administration, and an additional 400 probationary employees were laid off. And probationary employees are those that have only been with EPA for 2 years or less or so. It's significant because when you're seeing a lot of retirements already occurring in EPA, regardless of the change of administration, now when you're also laying off a good section of your younger talent or your newer employees, there's some real questions regarding how that impacts staffing in EPA. Tanya, you want to take over this next slide?
Thanks, Devin. So it's been quite an eventful month at the Department of Justice, particularly in the Environment and Natural Resources Division, which really, in many ways, is the pulse of the executive's litigating authority and environmental policy in many ways. So ENRD is comprised of about 600 lawyers and is 9 sections. And typically, what we refer to as the front office is the office that's comprised of a principal deputy assistant attorney general who is a political appointee, and then usually 3 deputy assistant attorney generals who are a mix of career SESs or senior executive service officials and political appointees. And so typically the career appointees or SESs are those who have served in the government usually for decades and have held leadership positions in other places in the division and are really there to create some form of continuity between the political administrations. This particular administration sort of strayed from the usual practice, which is to make the senior ranking deputy assistant attorney general the acting principal deputy attorney general until one is appointed. And so that position was left vacant for some weeks. And as a result of that, that meant that approval on certain high profile cases had to then go to the acting attorney general's office at the time. Each section obviously has a section chief, and we also learned in early January that 4 section chiefs were detailed to the Immigration Sanctuary Cities Working Group to work on litigation related to undocumented immigrants. And so those were the section chiefs of the Natural Resources, Appellate, Environmental Crimes, and Enforcement sections. And so again, section chiefs are going to be senior career service officials that have been with the department for quite some time. And so that obviously is a loss of institutional knowledge if they are to be reassigned. And then we later learned that some of them resigned in lieu of taking the reassignment. We also learned that the first ever director for the Office of Environmental Justice was placed on leave, and it seems as though the plan still is to eventually terminate that office in continuity with some of the executive orders, which we'll get into a little bit later today. We also learned that there are plans to RIF the entire law and policy section, and that section is the one that works typically with the Assistant Attorney General to set policy priorities and initiatives for the section. We still don't have an Assistant Attorney General nominated as yet. Obviously, that person will have to go through Senate confirmation. Going back to Devin's point a little bit earlier about this memo that was released, that was issued to both DOJ and EPA, it's still a little bit unclear as to what portions of it still hold, but we do know that it was unusually broad. Typically, the administration more so takes stays in high-profile litigation, and here we have the memo explicitly calling out the desire to institute a look-back period where for 90 days they're going to take a look at all of the cases and settlements that were handled during the end of the Biden administration will determine whether they intend to turn or change course. Another update is that we now have a principal deputy attorney general. His name is Adam Gustafson. He previously served as the deputy GC of EPA during the first Trump administration, and so he has some significant environmental experience. He helped defend the Affordable Clean Energy Rule. He most recently was a senior counsel at Boeing. And so I think that he's perceived at least as being well suited for the administration. His first priority, of course, is going to be to determine where the administration is going to change its position, particularly in litigation. And so we'll see and have to look out for the news to see who may be vetted to serve as Assistant Attorney General.
All right. Well, I'm going to turn now to the EPA itself. So what do we know about the current leadership at EPA? We know that Administrator Lee Zeldin has been confirmed. Lee Zeldin is a former representative, congressman from the state of New York. He doesn't have a whole lot of environmental experience, but what's most important here is that although he doesn't have a whole lot of experience himself, especially leading an agency like EPA, the nominees for the deputy positions and a lot of the chiefs of the various sections that are likely to be put in place do have a lot of experience. So if there's a fear that EPA won't have leadership that knows about the environment or knows how to lead, with Lee Zeldin in place, it seems like the deputies and other supporting, high-level supporting roles will be filled by those who do have environmental experience, including several that were in the first Trump administration. We don't know a whole lot of where the EPA policies are going to be landing, but what's really most clear at this point is some of the high-level points, and one of which is about 2 weeks ago, EPA, through Administrator Zeldin, issued a press release called Powering the Great American Comeback Initiative. And the purpose of the statement was to achieve EPA's mission while energizing the greatness of the American economy. And this comeback initiative statement has 5 pillars. You can see each of the pillars here. I'm going to run through them very quickly. But what you can see just from the titles of the pillars is that some of them are clearly related to the environment, protection of human health in the environment. For example, clean air, land, and water, the first pillar. But several of them are on their face a lot more focused on the economy, about rejuvenating the economy and moving forward with President Trump's initiatives to do so, rather than what you might typically see in other administrations focuses on policy initiatives related to substantive areas like water, air, climate change, et cetera. So the first pillar, clean air, land, and water, I think pretty much speaks for itself. There is a statement, however, that ties in to the point that I just made. To do all of these things that President Trump did in his first administration, advancing conservation, reducing air toxic emissions in air, and cleaning up hazardous sites while fostering economic growth for families across the country. So there's the economic tie once again. Now we get into the next few pillars, which are not as clearly tied to EPA's sole primary mission. So restoring American energy dominance, the statement begins by saying that pursuing energy independence and energy dominance will cut energy costs for everyday Americans. Now, what this means is a little bit hard to tell, but we do know that President Trump is interested in opening wildlife refuges for drilling and some other American-focused energy supplies that will potentially lower costs for consumers. The third pillar is called permitting reform, cooperative federalism, and cross-agency partnership. The purpose of this initiative on its face is to reduce permitting delays, the time it takes for permits to be issued. As the pillar explains, any business that wants to invest in America should be able to do so without having to face years-long, uncertain, costly permitting processes. So this pillar is going to focus on streamlining the permitting process to promote businesses and incentivize investment in the economy to create more jobs. The fourth pillar is making the US the artificial intelligence capital of the world. There's not a whole lot that's clearly related to the environment in this one. This pillar is about focusing on investment and the development of AI in the United States and being able to do so to promote the plans of President Trump to make the United States the AI capital of the world. And the final pillar is protecting and bringing back American auto jobs. And the statement here relates to bringing back jobs that have of course, been in part brought overseas. So investing in the domestic manufacturing of auto jobs, which is, as the pillar describes, the quintessential American industry. And the EPA will plan on partnering with leaders to streamline and develop smart regulations that will allow for the American workers to lead the great comeback of the auto industry. So what this all means in terms of actual policy implementation is hard to tell at this point, but the pillars are certainly different than what you might expect from a national compliance initiative that EPA typically puts out, and will likely update soon. EPA's Inspector General, not part of the EPA, but the independent Inspector General, was fired by President Trump. He was appointed by President Trump in 2020 and was fired along with about 7 or 8 other IGs. So we will see who the new Inspector General is, whose focus is to oversee and essentially audit EPA and ensure that issues that need to be addressed are addressed within the agency and make recommendations made to the agency. And then what does this mean for the day-to-day operations of the agency? Well, as Devin said, we have a lot of uncertainty at EPA in terms of not just policy focuses into the first 100 days and beyond, but the actual workers. So we've had about 400 probationary employees that have been fired immediately. This was last Friday. We have 168 environmental justice workers that were placed on administrative leave, which might end up being permanent. We've, at least from the folks at EPA that I have talked to, there is a lot, and seeing in the news as well, there is a lot of angst with respect to what comes next. So how that impacts day-to-day functioning. You see the slowdown already in terms of getting communications with the agency. And there's definitely a fear within the agency that more layoffs will be occurring.
All right. So I'm going to now take us through some executive orders. A lot of my practice is focused on the Clean Air Act. So since that's my baby, I tend to focus on that. So I apologize if it's too boring. But on the as far as the executive orders go, these first two have a direct bearing on Clean Air Act regulations. One is the executive order itself is issued January 20th, 2025. It's called Unleashing American Energy. It addresses a lot more than these two things, and we're going to be going over it in some other sections as well. But as it relates to greenhouse gases, one of the things that it requires is within 30 days of the order, the US EPA is required to basically reevaluate the 2009 greenhouse gas endangerment finding. I'll talk a little bit more about why that's so significant, but that's actually due by EPA tomorrow. Hopefully it's not come out while I've been talking here. The second thing is that he disbanded the interagency working group to estimate social cost. It's significant for greenhouse gases because it's very difficult from a regulatory perspective to justify a regulation if you can't show an impact. And greenhouse gases are notoriously difficult to show a direct impact for. So social cost is an important aspect. And if you're not considering it, you're not quantifying it, it makes greenhouse gas regulation more difficult. Next, this is a different executive order issued in the same day called Putting America First in International Environmental Agreements. They're always a mouthful. This one I won't spend much time on because it basically, the theme is it pulls us out of the international agreements. And from a regulatory perspective, it's showing a lack of consistency in this administration with what the international community might be doing. So essentially, as you've seen in the news, the message is the US is going to go it alone as it relates to its energy policy, regardless of greenhouse gas emissions. The other two executive orders I'm going to mention are much broader. One is the executive order issued again same day, January 20th, 2025, regulatory freeze of existing regulations. It attacks kind of the existing regulations, proposed regulations in different ways. It prohibits new regulations from being sent to the Federal Register until they're reviewed by the new administration. It withdraws ones that have been sent but have not been issued yet, and it extends comment periods for many regulations. Again, I'll go through how this practically might impact, but from a standpoint of, are we going to see new regulations? Certainly there's a big roadblock right now for anything that wasn't already finalized by the Biden administration previously. And the last one is also broad. This should seem somewhat familiar from the first Trump administration. This one was the end of January, unleashing prosperity through deregulation. It's basically one new regulation. If one new regulation comes in, 10 need to go out, as far as at a high level what the justification is.
And that's for each agency. If EPA proposes one new regulation, EPA has to find 10 to get rid of.
Correct. So this is much more aggressive than even during the first administration, when that ratio wasn't nearly as high. So again, it's attacking kind of the fundamental ability of EPA to issue new regulations. So like I said, I wanted to run through, I think the practical implications are perhaps more useful to many listeners of this webinar. So I'm going to run through these three examples and how they're impacted. So the first one is the greenhouse gas rule for utilities. Even if you're not a utility, this still, I think, is of interest to you. Obviously, the executive orders are now focused away from this type of regulation. The Biden administration issued a final rule to regulate greenhouse gases from coal-fired and natural gas utilities last spring. And without getting into the weeds, the rule basically requires pretty drastic greenhouse gas reductions through the use of carbon sequestration technology. In other words, injecting greenhouse gases down into the ground. That was challenged in the DC circuit by utilities and industry as a whole. And now, though, what you're seeing is that the Trump administration has asked, sorry, let me back up, and oral arguments were held for that case in December of this past year. So it was something that we were already going to be seeing from a judicial perspective. The Trump administration's DOJ has asked for that case to be put on hold while they review ultimately EPA's position. It's not beyond the realm of possibility that you could see EPA reconsider their position. Now, this is a long saga here with the attempt to regulate greenhouse gases from utility going all the way back to the Obama administration with the Clean Power Plan, then the Trump administration with the Affordable Clean Energy Rule. In that instance, it was also being challenged. It was repealed and replaced by EPA. So these executive orders certainly attack pretty heavily the ability for that rule to survive. And even if the Trump administration ultimately does not necessarily impact the judicial proceedings in the DC circuit, you still have the Supreme Court decision in Loper last year that eliminates agency deference with ambiguous statutes, which also creates a big roadblock for the utility rules to proceed. So the future does not look bright for the greenhouse gas utility rule. The next item here is the endangerment finding, and this I referred to before. Not to go too far back, but the ability of EPA to regulate greenhouse gases was affirmed by the Supreme Court back in 2007. And the Supreme Court at that time said, EPA, yes, the Clean Air Act allows you to regulate greenhouse gases, but you do need to make an endangerment finding that there is a danger justifying the regulation, which they did, which is why we have an endangerment finding. So the executive order asking EPA to reconsider now that finding would essentially undercut the entire ability to regulate greenhouse gases under the Clean Air Act at all. So of everything I've seen, I think this is one of the most significant. It's not to say that it would be successful and not challenged. I'm sure it would be, and it has been in the past and affirmed. But it's very significant that this executive order is asking EPA to take these actions. And the last thing I'll mention is the regulations on hold on the Clean Air Act. And whereas I know many clients get frustrated with the amount of regulations that exist in general, new regulations coming in that impact business, this kind of goes both ways. If you have regulations on hold, no, they're not putting a burden on your business. But there are also situations like, for instance, under the Clean Air Act, where states have to submit plans to the federal government to approve for state laws to be essentially effective and be incorporated into air permits. So right now there's several state plans that are being put on hold. They're not being approved by the federal government. So despite the intent being to make permitting easier and regulation less, in the short term, I think you're going to see some perhaps slowdowns in permitting given all these other issues that we're seeing.
All right. Well, Devin just covered a lot in a short period of time related to the stationary source aspects of the Clean Air Act. And I'm going to spend a minute or two talking about the Title II of the Clean Air Act, which relates to mobile emission sources. So the Unleashing American Energy executive order that Devin already mentioned had several aspects related to electric vehicles or mobile emission sources. The executive order calls for the elimination of the electric vehicle mandate, as President Trump calls it. Talks about removing regulatory barriers to motor vehicle access and ensuring a level playing field for consumer choice in vehicles. What does this all mean? The president, throughout his campaign, and now has made it very clear that he does not believe that electric vehicles, battery powered or otherwise, are the future, and that gas and diesel powered vehicles need to be available, and that regulation should not be promoting electric vehicles at the expense of gas and diesel vehicles. So this executive order is essentially saying that regulations moving forward shall not promote electric vehicles. And also the executive order calls for the termination, where appropriate, of state emission waivers that function to limit the sale of gas-powered vehicles. A quick step back, under the Clean Air Act, because California had regulated mobile emission sources before the Clean Air Act was passed in 1970, there is a preemption provision that allows California to have its own regulations. But in order for California to have its own regulations for a mobile emission source, it has to apply for, and EPA has to grant, a preemption waiver. And traditionally, EPA has granted just about every waiver. And what this is calling for here is the elimination of those waivers to prevent states from having their own programs. California has its own programs, and many states under Section 177 of the Clean Air Act are called 177 states that are allowed to adopt California's standards. And so this impact is going to stretch not just to California, but states this 177 states, but this impact from the executive order actually started before Trump took office. In the final days of the Biden administration, there were several preemption waivers that CARB had requested and that were pending with EPA and had gone through the public comment period but had not been ruled upon. And with the just days remaining, California, the California Air Resources Board, or CARB, decided that it saw the writing on the wall. It believed that either EPA was not going to grant the waivers in the final days of the administration, or in the Trump administration, these waiver requests would be denied. And CARB didn't want to have that denial on the record, so they withdrew several very important programs, including the Advanced Clean Fleets program for heavy duty trucks in California, and another waiver that promoted electric locomotives. And the executive order finally has the potential to withdraw, or under the new administration, we're likely to see the withdrawal or revocation of granted waivers. This overall leads to a lot of uncertainty for the future of electric vehicles, and at the federal level in California and in many states. A lot of automakers have invested a lot of money and many years to develop fleets for that are either hybrid or fully electric, and so there is a lot of uncertainty of where to go here with if the regulations shift about 180 degrees from where the Trump administration, from where the Biden administration was going. I'm going to turn it back over to Tanya to talk about NEPA.
Thanks, Joel. So as the litigator on the panel, I'll handle NEPA. And so for those that don't know, NEPA is the National Environmental Policy Act. And traditionally, NEPA is just a procedural statute. It doesn't really mandate that a particular outcome is reached, but it traditionally required federal agencies to evaluate the environmental impacts of their actions and decisions, particularly attached to federal spending. The law was passed in Congress in 1969 and was signed into law by Richard Nixon in 1970. And so really, over the years, we have not seen a lot of modification to the statute or regulation until very recently. NEPA created the CEQ, which is an acronym that I'll use again, which is the White House Council of Environmental Quality, to assist federal agencies with their NEPA compliance. And in 1977, it was Jimmy Carter that signed an executive order allowing CEQ to begin to issue regulations as opposed to guidance to federal agencies. So in the first 2 days of office, Donald Trump signed the Unleashing American Energy EO, which I won't read the text of, but that essentially makes some significant changes to how agencies going forward are to conduct their reviews under NEPA. So what does the order do? So first, it revokes President Carter's executive order to the government that the federal agencies had been relying upon to claim authority for CEQ to issue binding regulations. The order directs that within 30 days, or really by February 19th, CEQ would propose rescinding the existing NEPA regulations using a notice and comment process. I have gotten word this morning that apparently the administration plans to do this via an interim final rule, which could be obviously final upon publication in the Federal Register, which would mean that they would skirt the Administrative and Procedure Act requirement of notice and public comment, which I think is likely to get a heavy litigation response. So perhaps we will land in litigation or some outcome much sooner than maybe the year or two it would have taken the administration if they had followed the APA. The EO also directs CEQ to issue non-binding guidance on how agencies should implement NEPA in their environmental reviews. And the EO also requires that CEQ guidance and any agency regulations work to expedite permitting approvals and meet the deadlines already established in the Fiscal Responsibility Act NEPA amendments. And just as a reminder, in 2023, as part of increasing the debt ceiling, President Biden signed a package of legislation, the Fiscal Responsibility Act, and there were some amendments in that legislation to NEPA, which you'll see on a subsequent slide. The EO also directs federal agencies to convene a working group to coordinate federal agency efforts to update their own NEPA regulations. And it encourages agencies, again, to use all efforts to remove permitting delay. Next slide, please. I just wanted to also tie in another executive order declaring a national energy emergency, because obviously these two things are linked, even though the second order shown here does not reference NEPA directly, but clearly it gets at the heart of the president's plan for energy dominance and expansion of energy exploration in the United States. And so he is essentially clearing the way of what perhaps the administration perceives as environmental review and ways in which environmental review can delay the execution of projects. So what are the implications here? So for the time being, obviously everyone's wondering sort of, okay, well, what are the agencies going to do? How are they supposed to essentially do their jobs pursuant to NEPA? Obviously the statute does not give them enough to chew on, and we know that CEQ guidance obviously is in question. So I project that I predict for the time being at least that the CEQ regulations will remain on the books while we sort of sort out what may happen with this interim final rule, which would rescind them essentially. I think for the agencies, it's going to be probably the best litigation posture. The safest thing to do would be to follow CEQ regulations until there's something surer in place. All of this, of course, is complicated by what the judiciary is doing. So we have President Trump and the executive obviously trying to remove NEPA regulation and send it back out to the agencies for them to individually work and to coordinate to create their own. But then we have the judiciary, that the DC Circuit in the Marion Audubon case ruling that CEQ does not have the authority to promulgate regulation, and the en banc review there was denied, so that decision will stand. And then there's a federal district court case in North Dakota, which was decided recently, where a judge there said that the CEQ regulations before it also were erroneously promulgated. So the president seems to have a judiciary, at least, that is helping create precedent for the action that he seeks to take. I think there will also be a delay in the wave of litigation here while agencies revise their own regulation. I think it's going to be some time before litigants can determine sort of what test cases to use. And obviously they have all of the case law up until recent, right, that was used around CEQ regulations. There's a lot of obviously case law there that's well developed that they can perhaps seek to cherry pick to make an argument that the current agency review is deficient. But I think it's going to take some time for particular projects to develop that will be used as test cases, and so we'll have to see those outcomes there. And obviously this is a bit complicated also by LOPR, which we'll talk about at the end of the presentation.
Anything else, Tanya, you want to cover NEPA?
Yeah, I think I've covered what's in those slides already.
Okay, great.
You can move along.
Okay. Well, back to you, environmental justice, DE&I.
Yeah, so I'll go over at least the three executive orders issued by the president in January and sort of what they undo. And I know Devin will speak to the more broader implications. But immediately, one of the very first executive orders that the president issued rescinded about 78 existing executive orders that were issued under the Biden administration. And so one of them was Executive Order 14008. And that executive order was passed by President Biden in 2021. And it aimed to direct 40% of federal climate program benefits to disadvantaged communities, which established the Justice 40 initiative. That executive order also emphasized the importance of integrating climate considerations into U.S. foreign policy and national security decisions. And the executive order, also created the CEQ climate and economic justice screening tool, which was then used to identify the significant environmental, social, and economic burdens of disadvantaged communities that would then receive the funding pursuant to Justice 40. So that executive order has been revoked pursuant to the initial rescission of harmful executive orders and actions. In addition, that executive order also revoked Executive Order 14096, which was executive order issued by President Biden in 2023 that directed federal agencies to incorporate environmental justice into their missions and policies and to create offices where appropriate. And so we've seen that, obviously, the impact of that with the employees that have either been placed on leave or have been RIFed because they were working in environmental justice offices at respective agencies. Next slide, please. And then Executive Order 12898, which was one that was actually established by President Clinton in 1994. And this was one that required EPA to consider whether its policies and regulations disproportionately impacted minority populations. That also has been rescinded by President Trump. And it was reaffirmed, I guess, in a memo sent out by the now Attorney General Pam Bondi just a few days or a week ago as well. I think it's, I guess, pretty clear that the federal government will no longer have offices or federal dollars sort of allocated in this fashion This also has implications for NEPA review because President Biden had directed federal agencies to consider environmental justice as part of their NEPA review, and that obviously will no longer take place now. And I'll let sort of Devin take it from here in terms of additional analysis on impacts.
Other way.
This way.
Keep going. Keep going. There you go.
Got it.
So obviously, I mean, the message is super clear that from a federal perspective, EJ is, at least as it has been for the past, certainly the past 4 years, and really to some form the past 20 years, is no longer exists to some extent. And I guess I always like to boil things down in my simple mind of just practically how is it going to be impacting current projects? What's this immediate news mean for whatever might be going on in a particular business? And so I think a good example of that is the EJ Screen tool. For those of you that aren't familiar, it was the tool that US EPA was ultimately using from a permitting perspective, where you would look at socioeconomic data, economic data of a region, what the pollutant loading is for a region because of the industries that might be involved. And love it or hate it, it gave you kind of an objective view of, okay, this is in an EJ area where there's a high risk of EJ in the area. Many states adopted the use of the EJ Screen tool for their own EJ programs. And private industries adopted EJ Screen as a tool. So now that EJ Screen is gone with very little fanfare, I went last week and it just came up as an error came up on my computer. The question is, well, what are people in industry and state regulators supposed to use now? And I don't have a good answer for that. A good example is I was looking at Georgia's environmental justice program, and they have a fairly robust a book about what you should do to consider what you should do once an EJ area is identified. But at the very first page, it's, well, you have to go use EJ Screen to identify that EJ area. So if that is gone, then what's the other 200 pages of EJ consideration? So states are going to have a challenge of figuring out, do we want to continue to invest in it? And if we do invest in it, how do we essentially build that program ourselves? You have on the other spectrum, I do some work in Illinois, and Illinois has their own EJ screening tool that's independent of EJ Screen on the federal level. So you may end up seeing more models like Illinois in that instance, where the states do have a more robust program. I guess on the other side, just skipping in the interest of time to the last one is, how do private interest groups potentially fill the void? I do have clients that say, well, EJ's gone. It's been a big challenge from a permitting perspective for the past several years. Should we just get rid of the diligence that we've been doing? And the answer, in my view, is no. You don't do that, because you still have a lot of the private interest groups that have, they're much better informed now about the impacts of industry, the tools that can be used to monitor pollution, et cetera. And so you really do need to continue, I think, to be invested in these programs despite the lack of kind of a federal focus on it. It just may be more on your own than at the direction of the federal government. Go ahead. So we're going to wrap up here by just trying to talk about 3 categories of areas that will be impacted by everything that we've already spoken about. I'm going to jump around here. On the first one, on revisiting and revising national compliance initiatives, I think from an enforcement perspective, which is what I'm going to primarily be focused on, I think it's looking back really more at, we don't necessarily have a compliance focus. We do have those 5 pillars that the new administration or the new administrator rather has published, that Joel had talked about. But I don't know, to be honest, a whole lot what to do with those right now, because it just says protect air and water and land, and that's kind of what EPA's core mission is. So I don't have great advice from that perspective on what specifically this administration is going to focus on.
Although at some point we'll see new national compliance initiatives with some more detail.
Stay tuned for the Trump 2.0 webinar that we'll be doing. We'll have those answers. But in the meantime, I think it's really going with the last box there on the screen is, I think you're going to be expecting a lot less oversight from a federal perspective, whether that be because of lack of staffing, lack of funding, lack of focus. And if all of those things aren't there, then yes, the states may step up, and the states will likely step up under the cooperative federalism, which is another part of the pillar. But you also have a backstop there of, are the states going to be impacted by funding challenges as well? So what do you do if you're just trying to keep your business going and not, be in trouble, whether it be in this administration or the next administration? And that's why, from my perspective, I think you really look at, well, for instance, US EPA's audit policy is still there, and I don't expect it to go anywhere. It's a good opportunity to identify non-compliance and disclose it to US EPA, to maintain your internal audit programs, so that you're maintaining at a minimum the status quo, if not getting slightly ahead. And I think it still makes a lot of sense to be looking into those types of programs while you're waiting, whether that be this year or for the next 4 years, on what you're going to try to do to prevent enforcement. And the last thing I'll mention is when you do talk about where enforcement is actually filed, I do think there's a bit of a change in potential arguments that you would be making now versus what you may have made against EPA 5 years ago. With some of the Supreme Court decisions that Tanya is going to go into a little bit more, the posturing, whether it be you're actually planning on going to litigation or if it's just posturing in a enforcement settlement conference, I think industry, the regulated community, has some additional arrows in its quiver now to use against enforcement actions, against EPA actions in particular, that may relate to interpretations of statutes. So those are the two areas from an enforcement perspective that I think are areas to focus on. So I will kick it over to the litigator, Tanya, to let you know what happens when the enforcement goes wrong.
So generally, I think we're going to see an uptick in administrative litigation and de novo litigation, and I think that was going to happen sort of apart from anything this administration could have done or would have done. And that's because of the landmark decisions of Loper-Bright and Jarsky. And so essentially, those decisions sort of undermine agency deference and really allow industry then to be a little bit more aggressive in terms of challenging agency interpretation of ambiguous statutes. I think there's certainly an opportunity here for industry to rethink maybe some rules that potentially problematic in the past. And there's now an opening, I think, through what the judiciary is doing in terms of moving, probably taking back more authority from the agencies, and obviously the presidential agenda in terms of giving federal agencies less authority. I think there's an opening here for potential challenges, or maybe before you took it on the chin and sort of lived with a decision you didn't like. I also think that the nonprofit community is filling up its coffers in anticipation of potential challenges to a lot of what the administration is doing. And so to Devin's point, now is not the time really to rest on your laurels, because a lot of the federal environmental statutes as well as the state statutes allow for citizen suit provisions, right? And so a lot of litigation we're going to see come from conservation groups and other types of nonprofit entities, as well as citizens, to step in sort of the void that's going to be left by the federal administration. We're also seeing a lot of talk in the press about states banding together to make challenges to a lot of the administration's policies. And some governors have even been explicit and have said that they've reserved money in the budget as a budgetary line item to bring challenges. And so I think we're going to also see a lot more activity on the state AG level here as well. And so those are all reasons why now is not the time to fall asleep. I think companies need to be particularly vigilant on what is happening at the state level in terms of legislation. There are a lot of new bills under consideration that create mini CERCLA acts, include environmental justice. There's a lot of regulation now with things like extended producer responsibility. So there's a lot of activity happening, I think, at the state level. And so if you are an entity that is doing business around the country or throughout the 50 states, that's something that you definitely have to consider, also from a compliance and from a risk perspective. And certainly, last but not least, but of course, this administration is still, at least for the time being, involved in many high-profile cases which are still pending. And so we need to also be mindful of the impact of those decisions. So, for example, the CERCLA PFAS rulemaking is still pending in the DC Circuit. The SEC climate disclosure rule is still pending, although the acting SEC commissioner has indicated that this new administration is likely to change position from the Biden administration. But all of these decisions certainly and outcomes certainly are going to affect business and create new precedent maybe where there wasn't before. And so we have to be awake and prepared to really analyze how these things are going to impact industry going forward.
And Tanya, I'll just put an exclamation point on NGOs and citizen suits. I mean, it's clear from everything that I have seen, from press releases from NGOs to just what I'm hearing in the news overall, that NGOs have always been well funded. They are extremely well funded now, and a lot of money has come in the first 30 days. And they are ready to fight. So what that means for compliance and what that means for litigation overall would be, be prepared for citizen suits. We've always been prepared for them, but in the climate that we're in right now, there is really no substitute for, at least from an enforcement standpoint, there is no substitute for compliance. To eliminate, to the extent that you can, the opportunity for a citizen suit to file a notice of intent that US EPA would then, unlikely take its own action for. So to avoid this, the notice of intent in the first place, compliance is key.
And one more point just about notice and comment. I think for a lot of clients, I always sort of encourage them to be active in notice and comment periods for rulemaking that may not be particularly best for their business, because it creates sort of certain obligations vis-a-vis the agencies. But I think that industry now, I think, also needs to think about that a little bit more strategically now that we have the Loper decision, right? And the agencies were sometimes assured deference in certain situations, particularly again where the statute may have been ambiguous. But I think here that burden may shift a little bit, and so perhaps you might be able to get a different outcome here with a notice and comment period than you traditionally may have. Maybe the agency now is more willing to take a second look and evaluate sort of the finality of its decision making, given the fact that they're either have to then head into a court of first impression and don't have the benefit of having an administrative proceeding, or obviously don't have the benefit of getting some deference under litigative review or judicial review.
All right. Well, I'm going to spend the last couple of minutes talking about remediation. It's an area that I practice a lot in, and I know several of our listeners have remediation projects, whether they be Superfund or other projects around the country. In the first Trump administration, there was certainly a deregulatory focus, and in turn, the Trump administration decided that it would put a lot of its eggs in its basket into cleaning up Superfund sites, which sounded good in theory. A list of high priority sites that had been Superfund sites for a long time but hadn't moved quickly enough. The list was created. I had a couple of sites that were on that list, and I will tell you from my own experience that just being on the list did not really move those sites forward very quickly. And so what that means is in the second administration, I've heard rumblings already that Superfund sites, which are the most contaminated sites in the country that are put on the what's known as the national priorities list, Superfund sites might be a priority once again. I haven't seen that for sure, but if you look at one of the first pillar that I talked about earlier, cleaning up sites and having healthy land is on that list. So perhaps we will see a refocus on Superfund sites. Another area, somewhat related to environmental remediation is the concept of where we go with PFAS. PFAS, as many of you know, are man-made chemicals. They are called forever chemicals because they don't break down readily in nature. And under the Biden administration, there was a major regulatory focus on promulgating rules that would address PFAS. Now, what's interesting is the Biden administration didn't start this. Actually, the earlier EPA action plan, the PFAS action plan, was put out during the first Trump administration. So where will this administration go with PFAS? It's very hard to tell right now. There are several final rules that have been promulgated and are subject to litigation. Tanya mentioned one of the rules that designated two PFAS compounds, PFOS and PFOA, as hazardous substances, which allows EPA to require investigation and remediation under the Superfund law. That regulation is final, but it's been challenged in court, and a motion to stay that litigation for 60 days is now pending. We'll see where that goes. And then there was another very important PFAS rule, which set maximum contaminant levels, or MCLs, under the Safe Drinking Water Act for 7 PFAS compounds. That rule is finalized. That rule is subject to litigation, and that rule is now under a stay for 60 days that was issued about a week ago. So where do these rules go? Will EPA continue to defend these rules in court? Will it decide that it wants to abandon its defense of the rules? Will it decide to make some modifications to the rules through a rulemaking process? Yet to be determined where all of this goes. But when we talked earlier about if the federal government isn't taking action, then states might step in. PFAS is an area where that's already been the case. It's been the case for many years, with states passing their own laws to restrict PFAS in commerce and in remediation sites. These states will probably continue. There might be somewhat of a political red-blue divide here in terms of which states will pass regulations moving forward, as there already has been. The coasts, California, Washington, Oregon, New York, New Hampshire, Vermont, and then a couple of states in the middle like Minnesota have a robust PFAS regulatory program, and that will probably continue. But it's something to definitely watch out for, is whether the federal government will continue to have a PFAS focus. There's a lot of momentum behind it, and there's a lot of public perception that might actually weigh in favor of the Trump administration not completely abandoning its PFAS program, because people are concerned about PFAS, especially in drinking water. And with that, we are just about out of time. And I'm going to turn it back over to Devin.
Thank you. So because we are out of time, we do have a few questions, but what we will do is follow up with some responses to those after this presentation, so we're not keeping people from getting on to the rest of the day. Our webinar series, Transition, a Presidential Change, it will be continuing beyond the environmental realm on February 25th at 2 p.m. The next session will explore the opportunities and challenges shaping the M&A landscape in President Trump's second term, and we'll discuss the key differences from his administration, the impact of the current socio-political climate, and the role of emerging technologies and strategies in deal making. Sessions are held on Tuesdays at 2 p.m., so check your email inbox for invitations on upcoming topics beyond the one I just discussed. I hope you can join us. And if you're not currently receiving our updates and invitations, we invite you to go to Thompson Hine's website and register to receive our mailings underneath the Publications tab. So thank you again for all of your interest in attending today's webinar, and we hope you have a great day.